Good afternoon, everybody. We'll let people log in as they're coming into the chat room. We have a webinar with David Corman right now. Key clauses for our agreement of purchase and sales. So very important to word them properly, to have them there to protect our clients. Great topic, and we will be recording it as usual, so we can share it with the rest of the brokerage. So over to you, David.
Okay, thanks very much, Sabiha. Always great to be with Sutton Summit. And I got to tell you, I want to be honest with this group. This will not be nearly as much fun or as exciting as the in-person session that you had with my partner, Jonathan Cohen, a couple days ago. When he was in your office and had a session giving you some of his chosen life wisdom. So this won't be nearly as fun or as entertaining, but this will be very important, I think, for you as a realtor. And anyways, it was fun to see some people out there. I was able to attend for just a couple minutes myself to say hello on Tuesday, and then had to get to a meeting. But I understand it was a really good session with Jonathan. Those of you that missed it, I don't know if that was recorded, but anyways, speak to your colleagues. I think they found it an interesting thing, and thanks again, Sabiha, for putting that together. Okay, so we're going to talk about
it, David. And I was thinking about it that we should have these ongoing ones, and I would love to have one with you as well, because I think the life experiences bring so much. Funnily, so I think most of the people on this webinar did attend, so it's kind of good. I know Fernando was there for sure. So yeah, it's really good to look at that side of ourselves as well, the life size side of it. And it was really inspiring. It was a great session.
Well, look, we all struggle with certain things. We all struggle with different things. We're all trying to get, work-life balance and how we can be better professionals and how we can enhance our businesses and things like this. So having those type of discussions are great. So Sabiha, anytime you want me to come there in person, I can spend an hour and talk about Jonathan Cohen. No problem. Tell you all about his chosen life. So anyways, anytime I'm there, it's always a treat. But today we're going to talk about some things that you're probably taking for granted to some degree. Some of you may not even understand why you do certain things, why are certain clauses in the pre-printed form agreement of purchase and sale. Some of you are probably just ignoring them and not realizing the significance of them and how they affect your deal. So we're going to try and demystify some of that for you over the next few minutes. So let's get into it. I want to just skip through these introductory slides because I know we're running a little bit late today, and I want to make sure we get time to get through all this. And it is something we talk about in our podcast with David and David on real estate. We've talked about different elements of this in different podcasts. Sometimes we're talking about deposits, the significance of that. Sometimes we're talking about significance of some of the other dates, irrevocable dates, requisition dates, closing dates, time is of the essence, certain clauses. We're going to talk about all of that here. We've had many sessions, and we've got a couple coming up also in David Real Estate. We're even having a litigation lawyer we just booked in. So we're going to be recording something the end of the month with the litigation lawyer who's going to talk about some recent cases that he's been involved in where clauses that are in the pre-printed form become like critical in transactions and things like that. So stay tuned and please give us some feedback on David and Real Estate, and let us know if you want to be a guest yourself. We can arrange that. So the first thing I want to talk about is deposit. We get questions about this all the time. There's a standard provision in every printed form agreement of purchase and sale on deposit. It starts off with deposit submits, X dollars, and then you have a place in brackets, and you have to select one of these. It's either herewith, or upon acceptance, or as otherwise described in this agreement. You should never leave all three of them because that doesn't make it clear what it is. So you've got to leave one of those three and cross out the other two. So make sure you're doing that. And you have to understand the differences between what you're doing. So if you leave it, say, the deposit is going to be submitted herewith, so that means the check is going to be submitted right there. It's presented with the agreement of purchase and sale. Okay. If it's going to be upon acceptance, there's actually a definition of what that means in the next paragraph. And it means, for the purpose of this agreement, upon acceptance means that the buyer is required to deliver the deposit within 24 hours of acceptance. So understand that it's 24 hours of acceptance. If that's not good enough, or you want to change that, or you want to make it 48 hours, or you want to accelerate it, make 12 hours, you can do that if you change the language in that. So if you want it that the delivery of the deposit check is going to be within 12 hours of acceptance, then you cross out 24, you put in 12, and you get the parties to initial and agree to that. But in the first paragraph, you make sure it says that'll be submitted upon acceptance. You're crossing out the herewith and is otherwise described in the agreement. Now, sometimes some of this language isn't good. It's not what the parties really want or what you want if you're clients. So that's when you're going to choose the as otherwise described in this agreement. So if you're going to cross out herewith and upon acceptance, you're going to leave it as otherwise described in this agreement. And then somewhere in your schedule, you're going to describe exactly when the deposit is going to be submitted and who it's going to be submitted to. So make sure you're adding something specifically to that. Okay. And so just be careful, pay attention to this because it's critical. Okay. And delivery of deposit is a critical thing. That's what really ties up a property. It's signing the agreement of purchase and sale. And then we get asked the question, I'm just going to talk about this for a minute. We always get asked the question, well, what if we sign an agreement, no conditions, whatever, but it says the deposit is supposed to be submitted within 24 hours of acceptance, but then they don't submit it within 24 hours of acceptance. Does that mean the agreement is automatically terminating because they didn't fulfill it? And the answer, like you always like getting an answer from me, the answer is maybe. But the real answer is it's not necessarily terminated, okay? Because that you have a binding agreement of purchase and sale without there being a delivery of the deposit. It's not the deposit itself that makes it a binding agreement of purchase and sale. Signing the agreement makes it binding between the parties. And it's binding when there's no conditions or anything like that. Now, then the first contractual obligation that has to take place in the course of fulfilling that contract is that the deposit's supposed to be delivered within 24 hours. So if the buyer doesn't do that, the buyer's in breach of the agreement of purchase and sale. And now the seller has certain rights. They could choose to terminate the agreement of purchase and sale because the buyer's in breach. Or they might go back and say, hey, you didn't get it in 24 hours. Can you get it to me in the next hour, the next 5 hours, 10 hours? You can do an amendment to keep it going. Okay, but the ball's in the seller's court to decide what they want to do with it. So it's not necessarily an automatic termination. So buyers shouldn't look at it, hey, I've got a cooling off period. It says upon acceptance. So really, I got 24 hours to decide whether I want to go ahead with this transaction and submit the deposit. If, obviously they do, they got a firm deal and they're moving ahead because no one's breached the agreement. But if they don't, it doesn't mean that the buyer gets off. The seller could say, hey, I'm terminating you. And I don't have a deposit to keep, but I'm reserving my rights to sue you for damages because I had 3 offers available. I accepted your offer. The other 2 buyers have now disappeared, and it might take me a week or 2 weeks or a month to sell it to somebody else at the same price. I might suffer damages, and I'm coming after that buyer, the original buyer, because the buyer didn't fulfill the agreement and breached the agreement by not providing a deposit. Okay, so understand the significance of the deposit and the way the law works with them. So the next thing I want to talk about is the irrevocability clause, okay, which is in every standard agreement. It says this offer shall be irrevocable by, usually it's the buyer submitting the offer. So usually it's irrevocable by the buyer until 5 p.m. on May 8, 2025. Okay, so make sure you've got the right parties in there and you're filling both the date and the time. Because then it says after which time, if not accepted, the offer is null and void and then deposit will be returned in full without interest. So now a buyer submits an offer that says that. If the seller wants to accept the offer, then they just sign it back and accept the offer etc. If the seller wants to change anything that's in the offer presented by the buyer, then they're going to make those changes, and you're going to do that, or whoever the agent is acting for the seller is going to make those changes, initial those changes, and send it back to the buyer to sign or initial those changes. Now, when they do that, they also have to change the irrevocability clause, because now the seller didn't accept the buyer's offer. The seller is now making changes to it and submitting it. It's now a seller's offer to the buyer. So you've got to change the blanks that you filled in the irrevocability section. So now it's going to be irrevocable by the seller until maybe it's 12 noon on May the 9th. And now at that point, so now it's open to the buyer to accept it at that point in time. So if the buyer accepts all the seller's changes, they initial all the changes, including the changes that were made to the irrevocability clause, and then you'd have a firm deal. Or the buyer will say, no, there's certain things, I'm on another round of negotiation. I'm not accepting some of the changes the seller just made, so I'm making other changes and I'm initialing those. Now, again, the buyer has to change the irrevocability clause too, because now it's a buyer's offer again to the seller. So it has to be irrevocable by the buyer until whatever time and date that the buyer chooses, in which time they can't pull the offer back, and it's open for the seller to accept it on exactly those terms and conditions. So the problem that we're seeing in some of these agreements is, people are negotiating the body of the agreement, making changes, initialing them, and etc., but they're forgetting about the irrevocability clause and making sure you change and initial the things in there each time. Okay, because that's critical to the process as well. The next thing you have to focus on is the completion date. It says this agreement will be completed by no later than 6 p.m. on the 8th day of May, 2025. Okay, so make sure you're completing that. Now, the completion date and closing date are sort of interchangeable terms. It doesn't say closing or closing date anywhere in the pre-printed form. It refers to completion of the transaction and completion date. So that's the terminology you should really be using. So if you're doing conditional clauses or anything else, and it affects and you're referring back to the closing date, don't refer to it as the closing date, refer to it as the completion date, because that's what's really being defined in the pre-printed form as completion date. Nothing will generally turn on it if you're using closing date, because everybody sort of understands what it is, but technically you should be referring to a completion date, okay? The other thing I really want to point out here is people forget about, there's a second sentence or second paragraph in this pre-printed clause. It says, upon completion, vacant possession of the property will be given to the buyer unless otherwise provided for in this agreement. So that's the standard. They get vacant possession. If that's not what's intended, then make sure that is changed. If they're supposed to assume a tenancy, then make sure there's a clause in the agreement that says they'll be assuming a tenancy. Okay, and the second part of that sentence is unless otherwise provided for this in the agreement. So if in Schedule A or B or C or wherever it is, there's a clause in there that says that the buyer agrees to assume the existing tenant or the existing tenancies or assume the leases, and goes on and has that type of clause in there, then that's great, because that'll supersede this clause that says upon completion, vacant possession will be given because it is otherwise provided for in this agreement. Okay, and if you do have that clause in your schedule, you could cross out this vacant possession clause, because it's really not applicable, because you're going to deal with it in the schedule. Okay, so be careful with that and make sure there's nothing contradictory in those provisions.
David, can I
Yeah.
ask a question? So, back to the irrevocable.
Mhm.
Say somebody signs back and it's past the irrevocable. Is the deal dead?
Yes. If it's not accepted by the irrevocable time on that irrevocable date, if there's no agreement prior to that time and date by both parties agreeing to the exact same thing, there is no agreement.
Okay.
Okay. And the only way, if you
However,
send it 5 minutes later, the only way that that'll be binding is if the parties agree somewhere that that's going to be binding, that it was accepted 5 minutes later, and both sides are agreeing somewhere in writing that that's acceptable, because that's an amendment as well. Sabiha?
yeah, so you could You could bring back life into the offer by making it from whichever party it's being countered by. That party sends in the irrevocability scratched off from, say, from the seller to the buyer, right? And then they can reignite it, and then the other party can accept that offer.
Okay, is there any way also, like, if they, you can see that they were like waiting and humming and hawing and maybe looking at other properties and couldn't find them, could you then say, oh, well, now the price has gone up?
It's looked at as a completely different offer. Nobody's going to be accepting that agreement of purchase and sale, right?
Okay,
Yeah.
so you'd have to
Yeah,
do
it's
another
looked at
offer.
as a brand new offer, yeah.
Okay, thank you.
Okay, no problem. So the next clause that I want you to focus on is the title search clause. So there's this, it's in every agreement. These are clauses in every agreement. So the buyer is allowed until a certain date to check title. It's the lawyer we're doing the title search. And we refer to that date as the requisition date, but you're filling in whatever date that's going to be. And that's the date by which, when we do our search of title, if we find a problem on title that we want fixed up before closing, we have to send a letter to the seller's lawyer saying, hey, there's a defect on title, whatever it is. We describe what it is. And we have to send them that letter with a demand to fix it up, but we have to do that requisition and submit it to the other lawyer by that requisition date. Because if the requisition date is today, May 8th, and we search title, but I don't send the letter till tomorrow, but the paragraph 8 said May 8th, and I don't send it till May 9th, the answer I'll get back from the seller's lawyer is, you're out of time for submitting requisitions. You gave it to us too late. We're not fixing title. The buyer has to accept title with that defect in it. It's up to the buyer to go fix it up. Okay, as long as we submit it prior to that date or on that requisition date, then the seller has the obligation to fix the defect. Okay, now one thing I just want to tell you, let's say this offer was signed on February 1st, and it came into my office. You guys sent it over. You have a great admin department. You sent it over. We have great realtors. A lot of your realtors in your office actually send it directly to us. And then we get it a second time from your admin people, whatever. We got it in. You got a binding agreement purchase and sale. We get it in on February 1st. It's not closing until May 15th. And the requisition date here was May 8th. We got till today to search title. So I could search title today and submit it. And now I send a letter to the other lawyer today. Hey, we're closing in a week. We searched title. There's a defect in title. You might have to go to court, get a court order to fix this, whatever you got to do, and go fix it. The answer I might get back from the other lawyer is, we don't have enough time. We don't have enough time to fix this, and we can't fix it before closing. So either the buyers has to agree to an extension of the closing date. Maybe we can negotiate an extension to get it fixed. Or the buyer can accept title subject to that defect because I can't fix it before closing, or the agreement's going to be frustrated and terminated because we just can't fix it. Okay, so, and I'm going to go to the next slide because I'm going to skip to this section, this pre-printed form as well, because it ties into this, because it says, if within specified times referred to in paragraph 8 that I was just dealing with, any valid objection to title or outstanding work or deficiency notice, etc., is made in writing to the seller, in which the seller is unable or unwilling to remove, remedy, or satisfy or obtain insurance, save and accept the risk of fire. It means you can get title insurance in favor of the buyer, blah, 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 and which the buyer will not waive, then this agreement shall be at an end and the deposit monies paid shall be returned. Okay, so what this means is, if I submit that requisition today and we're closing a week from now, and the seller comes back and says, I'm unable or unwilling to remove it, I can't satisfy, I don't have enough time, I have to go to court, we need a month to do this. Why didn't you requisition this on when the agreement was signed on February 1st, we could have dealt with it. So that's the issue that I'm raising. From a buyer's point of view, I never want to search title on that last requisition date. In our office, our practice is we want to search title at the very first opportunity. As soon as a deal goes firm, it's not conditional, we're going to do our title search, because I want to do it in February so that if there is a title problem, I want to send my requisition letter then, not on May 8th, to the other lawyer, to give them lots of time, as much time as I can possibly give them to fix the problem. Because I don't want to get an answer back from the seller. Sorry, we can't fix it. Deal's off. You know, by the way, the seller's probably got some, maybe you can sell it for more money, but this gives them an out because we haven't given them enough time. So in our office, our practices, and I'm always preaching this to our other lawyers, and Jerry Corman started this years ago, and that's why he was one of the best lawyers in the industry, and Brian McGuire loved him so much because he was doing this. And I do the same thing. And Jonathan and the other lawyers in our office, we do that. And I'm always preaching to other lawyers, you should be doing this too, because we want our deals to close. Okay. We don't want someone to say, oh, I stood on my legal principle. We had the right to requisition it on May 8th, and we did. And so we did our job. Well, I would argue that no, you didn't do your job. If you could have requisitioned it a month earlier and you waited to May 8th, and now the seller doesn't have time to fix the problem and the deal falls apart. I don't think anybody has successfully done what they should do. So I get asked all the time from agents, like, what should we put in as a requisition date? And, you know, so generally, you know, on the buyer's side, you want to have as much time as possible to search title. But just because there's a date there doesn't mean that that's when they should search title. So the other important factor is you should be finding out who's the lawyer that's acting for your buyer client and what's their practice. Okay, because if you give them to May 8th and they actually take until May 8th to do it, they could be jeopardizing the completion of your deal. And if your deal doesn't close, you do not get paid. Okay, so you're going to be back finding another property for that buyer client because their deal fell apart. So be careful with the dates you're putting in, but also be careful with the lawyers that you're using to close these, and make sure you're using, you know, we're not the only lawyers that do it properly, but that's what we do. But make sure your lawyer, the lawyer that's acting for any of your clients, is a real estate lawyer that does transactions and understands the difference and does it. And I come across somebody that don't. So when we get requisition late on something, even if we can fix it, you know, they're giving us a week, and maybe it's something that we can get fixed within that week and we can close. But I don't just accept, I'm going back to have a conversation with that lawyer and saying, hey, you've had this agreement for 2 months and you give us 1 week to fix this thing, and we got to scramble to get it done. You're lucky. You and your client are lucky that we were able to fix this in time, but that's not good enough. You got to be better as a lawyer, and don't do that, and learn from this. And obviously, I'm trying to do this respectfully, and learn from this, and do your title searches as soon as you get the file in. Because when you're on the other side of it, when you receive that as a seller and you've got no time to deal with it, and you're put under that pressure, it's so unnecessary in most cases. So anyways, be aware of what the agreement actually says, but also be aware of what the parties should be doing and what the lawyers should be doing on this as well. So I'm just going to go back. So that was the title search clause. We got to a certain date to do our requisitions, and we're going to be checking that out. And then we have paragraph 10.
Sorry, David.
Yeah.
So, requisitions are like deficiencies that need to be handled before the closing or title
Yes.
search?
Yes.
Okay.
Think problems with title that we find when we do our title search. Okay.
Thank you.
So this is the other part of the clause that goes with it, which is the title clause. And just so you should be aware, because probably you aren't, or when we do our search and we check out title, there's certain things that affect title that we're not going to be able to get rid of, because it's really not in the buyer's interest to get rid of. Like most of the time, there's some restrictions or covenants that are registered against it. You know, it's part of the subdivision compliance. Like there might be covenants registered against the whole project, the whole subdivision, saying, you know, you can't raise farm animals on your property, or you can't put billboards on your roof, or things like that. Like things that everybody would normally want or expect in a normal subdivision. It might be restrictions on running businesses through your home or something like that. But those usually run with the land that usually affect the whole subdivision. So we're not usually requisitioning for those to get off. We can't get them off title. They have to stay on title. There's always agreements registered for utilities. So those are things that we see that are on title because there's sewers and there's pipes and there's electricity and there's cables and things like that. And the utility companies have to get access. Some of these are buried under land, some of them are overhead. They need access to it. So there's rights for the public utility to come on the property and fix it and service and things like that. And there's easements that are granted for those rights to come on the property to maintain those things, for drainage and sewage and all that stuff, sewers. So we need those things. Any buyer needs those things. So we're not trying to get rid of those things from title. We want to know what they are, but we're not usually requisitioning to get rid of them. And this clause says that specifically in this clause that we're not going to. You have to accept the title subject to those type of things that run with the land for utility purpose and everything. So that's right in the pre-printed form. So we're not going to ever say, oh, we found an easement for hydro wires, so we insist that you get rid of that from title of the property. They're going to say, no, we don't have to get rid of that. First of all, your client would be an idiot to want us to get rid of it because then they're going to have no electricity. But second of all, look at what the pre-printed clause 10 says. Your buyer client has to accept title subject to those utility lines. Okay, so just be aware that that's there. So the other part of paragraph 10, the title part, I think I pointed out to you, and it's really critical that if anything the seller is unable or unwilling to remove, remedy, or satisfy, or if they can't get title insurance coverage for it, then it'll be at an end. Deposit money is returned, okay? Unless the parties agree to something else. Then you're getting into negotiations. Can we extend? Do the parties want to extend? What are the terms of the extension to get things fixed up, etc.? So there's always that option. Okay, enough said about that. I want to move on to residency. So first thing you have to understand is, why is residency important? And residency is different than citizenship. So the issue here is, if a seller is a non-resident of Canada under the Income Tax Act, if they're determined to be a non-resident of Canada and they sell a property, then that property then the proceeds from that property will be subject to subject to a tax. And usually there's a withholding tax, an arrangement made to withhold some of the proceeds to make sure that the money doesn't leave Canada before the CRA has a chance to see if there's any taxes owed by that seller in Canada. Because they don't want the money to leave the country until Canada gets paid any taxes that are owing. What the actual clause says is, first of all, in Part A, it says the seller represents and warrants that the seller is not a non-resident of Canada and will not be a non-resident of Canada on completion. Okay, so if that's true on completion, and this normally what happens is, as evidence of the truth of that, is usually a standard closing document is the seller will sign a declaration on closing that the seller is not a non-resident and will not be a non-resident at the time of closing. So if they provide that and the seller is not a non-resident, there is nothing further has to be done. It closes, seller gets their money on closing. Okay. Part B is different. If the seller is a non-resident on closing, it says the buyer is going to be credited towards the purchase price with the amount necessary for the buyer to pay anything that's owing to CRA, the Minister of National Revenue, to satisfy buyer's liability respective tax payable by the seller. Okay, under the non-resident provisions of the Income Tax Act. So first of all, the potential tax that a seller might have, it's not restricted or limited to taxes just from this property. Just, the seller bought this property, sold it at a profit, has a capital gain on it, whatever it is, whether it's principal made capital gain or whatever. It's not just taxes that might be payable on this property. It's any taxes that might be owed by the seller in Canada for anything. So it could be income taxes, it could be HST that they hadn't remitted, it could be capital gains. It's any tax owed to Canada. So when the CRA reviews a seller's request, to look at their affairs to see if they're allowed to get their money, the proceeds from the closing, they're looking at the overall tax obligation of the seller. But the quirky thing about this clause, it says the buyer's entitled to a credit on closing for the amount that the ministry might require to satisfy it. So what is that amount? For most residential properties that are being sold, that amount would be 25% of the sale price, not the net sale price after a mortgage was paid off or commissions are paid. 25% of the sale price. If the price was $1 million, then the potential liability is $250,000. If it's an investment property, then it goes up to 50%. Okay, so if it's $1 million, then there's a potential 50% of that, $500,000. So this clause says the buyer can get a credit on closing for $500,000 because that's the potential liability. And why is it a potential buyer's liability? This is taxes owing by a seller. But under this provision of the Income Tax Act, it says the buyer is going to have to pay the taxes owed by the seller in Canada unless the buyer does certain things to make sure that there's nothing involved. It's a very quirky thing that they actually impose the buyer with a potential liability to pay for the seller. So in practice, this is what we do as lawyers. We generally do not give the buyer a credit. We're not giving the buyer a credit for $500,000 on $1 million purchase on closing. What we do instead is we negotiate an undertaking and holdback between the lawyers, between the buyer's lawyer and the seller's lawyer. And this is sort of standard practice, what we do. And we say, okay, let's just assume it's not an investment property. It's just a residential property that they were living in. So it's a 25% liability. So we would get the seller's lawyer to agree to hold back 25% of the sale price in trust until the ministry issued a certificate under Section 116 of the Income Tax Act. So we'd hold back $250,000 in trust, and the parties would undertake, the lawyer would undertake to the other lawyer, I'm holding it in my trust account until we get a certificate from the ministry. And when we get that certificate, it's going to say that there's no taxes owing. You can go ahead and release it, or it'll say pay X dollars to the ministry and the rest can go to the seller. But we can't do anything with the money that's going to sit in a trust account until we get that certificate from the ministry. So that's the way in practical terms that we generally deal with it. So before I leave this issue, I just want to go back to, remember I said being a non-resident is different from being a citizen. It's got nothing to do with citizenship. So a Canadian citizen, born in Canada, raised in Canada, lived in Canada their whole life, but now is a snowbird going to Florida for a couple months a year, and then it becomes a few more months. And they could become a non-resident of Canada for the purposes of this. Now they're trying to sell a property in Canada, and we have to determine whether or not they're a non-resident. So in the 1 year period leading up to the closing date, we count the number of days they're in Canada and the number of days they've been out of Canada. If they're outside of Canada for 1 day more during that 12-month period than they were in Canada, they become a non-resident and subject to this clause. We got to deal with them as a non-resident. Okay, so we're always using all our fingers and our toes to count up the number of days to determine whether or not someone is a non-resident of Canada for the purpose of this. Got nothing to do with whether they're a citizen. You can be a Canadian citizen, but you might become a non-resident depending on how much time you spend out of the country. And this would apply to you, okay, or to that seller. Okay, I want to talk next a little bit about time limits. And we've done a few podcasts on this topic, and I know I've talked to your group about this in the past too. there's a provision in the agreement. I'm going to read it to you here. It's right here. Time shall in all respects be of the essence hereof, provided that the time for doing or completing of any matter provided for herein may be extended or abridged by an agreement in writing, signed by the seller and the buyer or the respective lawyers who may be authorized in that regard. Okay, so what does that mean? Time in all respects shall be of the essence. There's a bunch of clauses that I've already talked about where there's a time factor. It's the time to deliver the deposit. It's the irrevocable date and time. It's the requisition date and time. And then it'll also be, and the closing date, the completion date and time. And then it'll also be any conditions that you put in there, where the condition they've got, you know, so many days to provide a status certificate, so many days to do an inspections, or you have until such a date and time to get your financing. Anything that's got a date and a time in it, this clause is so important. Time shall in all respects be of the essence. So what that means is those dates and times have to be strictly adhered to. You can't be a minute late. You can't be a second late. You can't be a day late. You have to comply with each one of those strictly. And if you don't, then you're in breach of the agreement of purchase and sale, unless there was an extension or abridgment, which has to be in writing and has to be signed by both parties or by their lawyers who might be authorized to sign it on their behalf. Okay, so if anything can't be met, if it says you got to deliver a survey within 3 days of acceptance agreement and you can't get it done and you need a 4th day, you have to go back and get an amendment. Okay, you can't just say, oh, sorry, couldn't get it to you on the 3rd day, but here we are, we're an hour late or we're a day late, here it is, everything's good, because everything's not good. Okay, the other side can say, no, you didn't deliver us that in time. Section 20 said time is of the essence. You failed to deliver that in time, therefore you're in breach of the agreement purchase and sale, therefore we have rights. And the rights might be to terminate the transaction, the right might be for damages, might be a combination of both. So never put your client in those positions. Strictly adhere to all those time and dates that are in there, and make sure the other side is doing so as well. And if you're not sure, you check with the lawyer acting on the file and how it should be interpreted. But it's a critical aspect of all real estate transactions that you strictly comply with those provisions. And anytime you think you're going to have a problem, that's when you have to get an extension of it, and it's got to be in writing, and it's got to be signed and accepted on the same terms by both sides. So be very careful with that. Now, I want to move on to another section that probably a lot of you aren't even aware is in there, the Family Law Act clause. So sometimes this issue comes up, do I need spousal consent? Do I not need spousal consent when someone's selling a property? Or I know this was owned by Mr. Smith, but I think it's their matrimonial home, so do I need a consent of Mrs. Smith? Yeah, yes, you do, if it's a matrimonial home. But there's actually a specific clause in the agreement that says the seller warrants that spousal consent is not necessary under the Family Law Act unless the spouse of the seller has actually executed the agreement, has provided a consent. Okay, so spousal consent isn't always necessary. It might be owned by Mr. Smith, but if it's an investment property and they're not living there, it's not a matrimonial home, then the consent of Mrs. Smith isn't necessary. It's Mrs. Smith has to consent if it is a matrimonial home under the Family Law Act. So that's who needed consent. Okay, but there is this clause that people aren't even aware of, that spousal consent is not required unless it's actually there. Okay, so that's a representation by Mr. Smith saying, there's no consent here because I don't need my wife's consent. And I've actually provided a warranty in the agreement that I do not need my wife's consent, that it's not a matrimonial home. I don't need that consent. If it turns out that's false, because it actually was a matrimonial home, then the seller, Mr. Smith, is going to be in breach of that clause because he made a representation that wasn't true. So just be aware of that. Next thing that's really important, and after I do this, I'm just going to show you some condo clauses, because condominium protection are a little bit different. But there's a clause in every printed form that agreement's in writing. So if there's a conflict or discrepancy between anything that's added by way of a schedule, and you always have schedules to your agreement. You got a Schedule A, Schedule B, Schedule C, whatever you're adding. If there's a conflict between any provision that's added in a schedule and any of the pre-printed clauses that are in the form, it says that the added provision will supersede the pre-printed clause. So make sure that whatever you're putting in your schedule is what you really want. And if it turns out, and that's what's really being agreed to, because if there's a conflict between that and the pre-printed form, it's what's in the schedule that's going to govern if there's a discrepancy. Okay. And the other thing you should be aware of, anything you do attach as a schedule becomes part of the agreement of purchase and sale. It's the original body of the agreement plus any schedules that are attached to it and signed and accepted by the parties, which means that if there's something that's not attached as a schedule, it's not part of the agreement of purchase and sale. So if there was something described in the MLS listing about the property that, and it might even be a rep and warranty of some sort, or the appliances that are included or what that are being offered sale, that listing agreement is not binding on the seller unless you actually attach that listing agreement as a schedule to the agreement of purchase and sale. So if you want that in, then make sure you attach it and make it part of it. This clause goes on to say that there is no representation or warranty or agreement or condition that affects the agreement unless it's expressed herein. So everything has to be in writing. It has to be there, which means you can't rely on verbal representations that were made by you as an agent or by the other agent or by the seller to the buyer or by the buyer to the seller. Whatever those conversations was that are just verbal are not binding on anybody. So if you want it to be binding, you've got to make sure you draft a clause and get that accepted, because only what's in writing that's going to be binding on the parties. So that's very critical. Now there's a little bit different, some different clauses that are in the form that you use for a condominium. And I hope that all of you, if you're acting on a purchase or sale of a condominium, that you're using the condominium form and you're not using the resale form for non-condominiums, because there's differences right in there. So the title clause is a little bit different. It has everything that was in the other one, but because we're dealing with a condominium, it also has some other things here that we're going to accept title with some, whoops, I just skipped over it, with some other things too, because there's look at paragraph C here, we're accepting title subject to the provisions of the Condominium Act and regulations, and there's a declaration from the condominium, there's bylaws and occupancy standards and common element rules and things like that. So you're buying a unit in a condominium, the buyer's not going to be able to negotiate out of any of those things. So they're going to accept title subject to those things. Now we go through a process of looking at a status certificate to make sure there's nothing, no breach of those things, there's no issues with those things, but otherwise we're accepting that those things are part of it, and it's not a valid requisition for a buyer to say, hey, get rid of the condominium declaration that's registered on title because I want clear title. No, the buyer has to accept title subject to those things, okay, as well. Now, there's also a clause in the pre-printed form on condominiums with respect to the status certificate, where the seller represents and warrants that there aren't any special assessments contemplated by the condominium corporation. So it's different. The status certificate will say if there's anything that's been issued, anything that's already outstanding, there is a special assessment. This paragraph people aren't aware of sometimes, right? In the pre-printed form, it also says there are no special assessments contemplated. So it might be that, they know they got to replace the roof or the elevators and they're trying to figure out how to do it. Maybe they've given notice of a special meeting to try and have a discussion and figure out, do we finance to pay for the elevators, or we can do a special assessment? So that is now a special assessment that's being contemplated. So just by calling for a meeting or having had a meeting and there's been discussion, so that's a contemplated special assessment. So if there has been such a thing, then the seller shouldn't be representing and warranting that there have been no special assessments contemplated. So you got to add something in your schedule. So yeah, there is a there was a meeting, or there's a meeting coming up where it's going to be discussed because it is being contemplated. You have to disclose that. And this is why. Because in the absence of you disclosing it, it says the seller is representing that there aren't any. So make sure whatever you're doing is going to be accurate and truthful. Okay. So that's an important thing to remember. There's another clause in the condo thing about meetings, seller representing warranting that at the time of acceptance of the offer, the seller has not received a notice convening a special or general meeting respecting, any significant changes or alterations to all these things are under the condominium. So again, if there haven't been any, it's fine. Seller can represent and warrant that. That's what the pre-printed form says. But if there have been meetings or a notice of a meeting, then that should be disclosed in the body or in the schedule, because that schedule will supersede this language. And we don't want our sellers to be falsely representing or warranting anything. So just be very careful of that.
David,
Yeah.
what if an inspector came in and they said that something needed to be done on the property? In this case, it was insulation in the attic, and the condo core is like taking really long to like respond to like when they'll be doing that, or like even like with shingles on the house. Like, is there any sort of remuneration that you can get to like get this done?
Well, there's a whole bunch of factors that might come into play here about whose obligation is to fix it. Is it the condominium corporation that's doing it? When's it going to be happening?
If it's the
When's it,
condo core
and
that's
then when's it going to be paid
responsible?
for, and what their plan is for how it's going to be paid or financed, or when it's supposed to be paid. Sometimes it could be the seller's responsibility to pay it. Sometimes the cost can be passed on to a buyer because the benefit is going to all accrue to the buyer. It's going to be fixed up or repaired after the seller's long gone, and the buyer is going to get the benefit of those repairs. So we have to look at each factual situation on its own to give proper advice on that. Okay.
Okay, thank you.
Now, in my remaining few minutes that I have here, I just want to run through some of the standard conditions. If it's a condo, and you've got all these type of clauses, you've got better clauses probably, but these are, please don't take any of these clauses to be the verbatim, and you've got great clauses in your system there. But, there's you should always have, when someone's buying a condominium, don't let them buy without a status certificate review. If you need a conditional on the buyer's lawyer reviewing it, make sure you put a condition in there and you complete it properly. So we have a couple different examples here. Usually a seller is providing the status certificate and paying for it and getting it and providing it to the buyer within so many days. And then once it's received by the buyer, they have so many days to review it and make sure that they're satisfied with it. Similarly, make sure if you can get an inspection, you should always try and get an inspection done if possible. And if you need an inspection condition, make sure you're using proper language to get a conditional on inspection. There's just an example clause for doing it. Here's one. Sometimes you do an inspection and there's a whole, there's 10 things that have to be fixed. There's a whole bunch of repairs. So now how are you going to deal with that? Sometimes you put in a clause that's going to allow the seller a certain time period. The seller's going to, I'll fix it, and we're going to do it by a certain time and date, etc. I think you always got to be very careful with that, because anytime the seller is agreeing to fix certain things, you want to make sure they're fixing it by a certain date, but you also want to make sure that it's being done properly, professionally. If it's electrical work, maybe, or you want a licensed electrician to do it, not the handyman seller. If it's plumbing, maybe you want a licensed plumber to fix it, and you want evidence that was done by a licensed plumber. So be careful with your language that you're putting in there if you're going to allow the seller to remedy it. And whatever you're going to do, if the seller is going to do that, you're going to always want an opportunity to re-inspect and make sure that it's done properly. So you may need a re-inspection clause too. I always encourage people, we get these laundry lists of things that have to be fixed. Sometimes the buyer is better off to negotiate instead for the seller to fix all those things, and then got to be satisfied that it's fixed properly by licensed people, and the buyer's never going to be happy. And so maybe they're better off trying to negotiate an abatement in the purchase price to cover the cost of doing it, and the buyer will accept those warts and defects, and the buyer can use their own people to fix it after closings. A lot of times that's a better way to go, but be careful in what you're doing. And sometimes you got to get us lawyers involved. So when you can't get everything you want in an agreement, you're not sure if you got a clause in, you're not sure if you accept the language, please try and reach out before you accept it, okay? We try and make the lawyers in our office very accessible. If you can't get me, I'll make sure one of the other lawyers in our office can jump on something quickly. We do our best for that. I think we do better than most. But if all else fails, get a lawyer's approval clause in. Conditional on the lawyer reviewing this with whatever time you could get. If you can get a day, great. If you can get 2 days, great. If you can only get 3 hours, great. Get 3 hours and we'll get someone to look at it within those 3 hours. But that's better than not having it in there. Okay, conditional on financing. Be very careful with this because financing is a real issue these days. We want to make sure they get proper pre-approval and they don't waive conditions unless they know they can comply with their pre-approval. So make sure they have enough time to get their proper pre-approval before you waive a condition like that. And then when you have a financing condition in there, buyer can't say, "Oh, I got a financing condition. And I've got 5 days to get to approve for finance." That gives me a get out of jail card, and I could just decide to get out of this and change my mind or get cold feet or whatever. It's a built-in cooling off period just because I got a financing condition. Well, that's not true, okay? Because a buyer has to take some steps in good faith to try and get financing. And if a seller challenges them on that and says, "I don't think you did anything. I don't think you acted in good faith. You just got cold feet and waived it. I want evidence that you actually tried to get a mortgage approval," that issue of good faith can come into play. So just be careful with it. It should be bona fide attempts to get financing. Sometimes we're going to put in a clause that'll be conditional on the sale of buyer's property. So this is where someone is buying first, selling later. Okay. That works if you can get this type of clause in, so you don't let your buyer client be unprotected. So you negotiate this type of clause. We're gonna buy this, but it's conditional on 30 days, 10 days, whatever you can get, 45 days, because we're gonna sell our property. And if I don't sell, my buyer client can get out of the transaction. So that's the type of clause you would use there. Now, sometimes we want to couple that type of clause with an escape clause in favor of the seller. The seller might say, "Great, okay, I'll accept your offer. You got 30 days to try and sell your own property before you firm up. But in the meantime, I want to be able to continue to offer this property for sale. If I find another buyer that's going to give me an unconditional offer, then I'm going to throw it back to you and I'm going to give you an hour or 2 hours or 5 hours or something to waive your clause and firm up. Or that agreement will terminate and I can accept my second offer." So sometimes we're going to use this escape clause. So make sure you've got that in your toolbox as well. Okay. Sometimes the seller needs to find accommodation. They might need an accommodation clause. They need so much time to find a place to live. Sometimes we got to deal with this when there's a short time frame. So just so you've got a clause like that available as well. Assignment clause. I want you to be very careful with assignment clauses. And this is really critical. So an assignment clause where a buyer, Mr. Smith signs an agreement, but there's a clause in here that says the buyer covers and agrees that the buyer will in no way directly or indirectly assign or lease, etc., or advertise for the sale of the rights under this agreement prior to completion without the express written consent of the seller. Such consent shall be granted or withheld at the seller's so option. So it might say something like that. Or it can say the buyer has the right at any time prior to closing to assign this agreement to any persons or corporation, either existing or to be incorporated, upon delivering of notice of that assignment, and the assignee agrees to be bound, then the original buyer shall stand released from further liability hereunder. That is a critical one. We just did a whole podcast on this very clause, okay? Because what happened in that case was buyer, Mr. Smith, signs an agreement, then he incorporates a company that owns nothing, He can't close. He assigns the agreement to that company that owns no assets. The company doesn't close, and there's no transaction, nothing happens. So now the seller wants to sue the company, but they can't collect anything from the company anyway. So the seller tries to sell Mr. Smith too. And the judge says, no, Mr. Smith had the right to assign it. That's what your clause says. It says the buyer, once they assign it, the buyer shall be released of any further liability. So never do that. Don't accept that clause ever. Okay? What it should say is the original buyer, Mr. Smith, will only be released from liability upon successful completion of this agreement by that shell company that has no assets. Okay? Then the seller has the right to go after Mr. Smith for the personal assets if the company doesn't close. So never accept an assignment clause that says the buyer shall stand released once the assignee accepts the agreement. Okay, you want to keep that original buyer on the hook and be responsible until that transaction actually closes. If it closes, great. From that point in time, it's just the company is the one that gets title. So that's really important. Chattel and equipment is the last thing I want to talk about here. Condition on if there are rental agreements that affect anything, make sure you find out what they are. We don't want any buyer to assume obligations to pay things off unless we know exactly what it is. We might want the seller to finish paying off on a rental agreement to get ownership before, so that on closing, the buyer will own that equipment. So be careful with that. And if there are rental agreements, we want to see what they are. We want to review them, etc. So it's not enough to focus your attention on chattel equipment, just saying, oh, all chattels and equipment will be in good working order on closing. Yeah, we need something like that. But we also want to know who owns the chattels. Are they subject to a lease agreement, a rental agreement? If so, is it going to be paid off before closing and the buyer is going to get ownership? Or is the buyer supposed to assume those rental agreements? So that's really important to ascertain as well. So make sure you pay attention to that. So with that, I'm going to throw it back to you, Sabiha. I know we're a couple minutes after 3, but we started a little bit late today as well. So
Right.
I stick around for a few minutes to answer questions. If not, please reach out. If you have any specific questions, please reach out to me privately. Best way to get me is by email, and then we can arrange for time to speak if necessary. But Sabiha, I don't know if you have anything there.
Right. Does anybody has any questions that they'd like to ask? I just want to point
I have
out
a
that
question, Sabia.
sure, Nadir.
Sorry. So one of my last recent deals, the seller was telling me to do the title search a month ahead, which I was always taught at least like 2 weeks is the max. I don't know. I understand what David said, that his firm do as soon as they get the transaction paperwork.
Yeah.
But I just want to make sure, like, as far as we are us writing an offer, is 2 weeks sufficient, or should we go a month?
Well, for the reason that I explained, it's better for the closing of a transaction, for the requisition date to be as soon as possible after the agreement is signed. Okay? So you want to be fair to the lawyer acting for the buyer too, that, give them at least a few days, give them a week, give them 10 days, depending on what it is. But everybody should be trying to look at title as soon as possible, so there's enough time to fix any title problems. Okay? So if we get an offer in from you or anybody that says, hey, we just accept this offer, it's not closing for 2 months, but we've only agreed to 1 week to search title, I don't freak out about that, because we want to make sure we're doing our title searching before that week in the normal course. Okay. Other lawyers will freak out on you sometimes. Like, why'd you only give me a week? I'm too busy. I got closings. I got this, I got that. I got to be in court. I'm not even a full-time real estate lawyer, whatever. Okay. So you want to make sure that your clients are in the hands of lawyers that can deal with it. If you're not sure, check with the lawyer that your client intends to use. How much time, can you get the search done in a week, or do you want it 2 weeks or whatever? But the other question should be, if they're saying, no, I want a month, well, why? Because you don't really want that lawyer to take the month to do it. Okay, you want them to search title sooner so so that the parties can fix the title problem. Okay, so I'm always fine. Like I think the closer the date, the requisition date is to the agreement is better than it for being close to the closing date. Other lawyers will tell you, no, I want as much time as possible. So get the latest date you can. Get me, to the date that's a week before the closing. And to me, it's just wrong, because if they wait till that day and they find a title problem, now they're putting the whole transaction in jeopardy. So be careful.
David, I
not to
have a
get
quick
the
question on that.
Yep.
Would that not cause any problems like later on? Say if it's like closing is in 2 months or 3 months, are they not able to put another lien or something like that in place on the title at that point?
That
Isn't
can
that
happen
too
at
much
any
time?
point. That can happen anytime. We can have our title search days today. I requisition it. It's May 8th. We're closing May 15th. Something can get registered between May 8th and May 15th. There could be a construction lien on, we're always searching title again before closing. But in the normal course, things like that aren't happening. Now, if you know that a property's, that there is ongoing renovations and construction or something like that, there is always potential for liens. So you should know that too. But still, you
I
gotta
was thinking more in terms of
draw
like legal
line.
action, right? So if you're because the APS starts, the MLS starts showing that the property is sold
Mhm.
firm, right? And the price is out there and all of that is there. So anybody who's contesting title or something, they can put a lien on it in that 2 months. So your
Yep.
client is saved from
Yep.
it if it's right.
No, they're not safe from it, because if they put it on after we search title and it shows up later, but then we discover before closing, it's still something it's going to screw up our deal. We're going to have to deal with it. Maybe we still have enough time to deal with it, but it's still a better practice to search title first or as early as possible.
Okay. Any other questions, guys? Okay,
I
very
think
good. Sorry about
that was
Okay.
my worries too, Sabiha, that the title search, if it's too much time, they could put a lien or get a mortgage on it. So a lawyer can basically do a title search multiple times. That's what I understood from David, right?
You're always able to do that. There's costs. The government charges every time you search or then do another sub search. But if anybody has an idea, there's a potential lien. So sometimes we'll do another sub search and just check title of it, make sure nothing else has been registered since the time. We're always sub searching title before we close. Okay, on the day of closing, to see if there was anything else that was registered from the time that we did our title search until then. But if you're in a situation where there's potential, if it's a mortgage, a client's going to know there's a new mortgage going on. Like they're going to bring that to the attention of their lawyer. The lawyer is going to be involved in that. It's usually like something like a lien could go on. But so we have to know if there's any, if any potential liens. And if so, sometimes we'll go back and take another look at title. Okay. But otherwise, we're in the normal course, we're searching title the day of closing in any case.
Thank you, David.
All right.
Thank you, everyone.
I gotta run. So anything else, please reach out to me and I'll be happy to answer any further questions. Okay.
Thank you so much, David.
Okay. Thank you, everybody. Bye.